Good afternoon, and a very warm welcome to this talk about partnership expulsions. My name is Julian Norris, and I'm a consultant solicitor at BMA Law. I specialise in dispute resolution, partnership law, commercial disputes, and property disputes. I qualified as a solicitor in 2005 and have worked at large commercial firms and as an in-house solicitor, both in local authority and within the NHS, so in both private and public sectors. So this afternoon, we're going to have a look at the particularly complex species of partnership dispute, expulsions. Expulsions can be difficult and should always be approached with caution if you want to avoid potential mishap. So here are the headlines. We will go into some detail and look at some important cases, but I do need to make clear that this is a general talk. These situations are always very fact specific. And so today, I'm not giving you specific advice about any particular dispute that may affect you. You will also appreciate that I may be unable to answer some specific questions that you have about any brewing dispute in this forum, but I should be pleased to discuss them confidentially with you in private. So to the basics, partnership is the relation which subsists between persons carrying on a business in common with a view to profit. The 1890 Partnership Act sets out the fallback position where there is no partnership agreement or the agreement is silent on a particular point. Section 25 of the Partnership Act prohibits expulsion without express agreement. So you cannot expel or compulsorily retire a partner from a partnership without it. You must have the power. You would instead have to dissolve the partnership. And this is important because when a partner leaves, dissolution must follow. Dissolution means that a lot of potentially undesirable steps must be undertaken. Accountancy, contractual, insurance, liabilities, regulatory. If your contract with the ICB is as a partnership, then it cannot just automatically pass to a single hander because there are different forms of contracts. And where two partners split, the ICB may not agree to a new contract for the single-handed GP. So if there's no partnership agreement, you will need to carefully negotiate the terms of any departure. Eaton and Caulfield is an LLP case, and Mr. Eaton, who had been expelled by Mr. Caulfield, claimed that he had been expelled from the limited liability partnership and that the expulsion was unfairly prejudicial. He, in fact, brought his claim under Section 994 of the Companies Act, which is in play with LLPs, but this is equally applicable to a partnership. Or this case, the facts from this case are applicable to a partnership situation. The preliminary issue that came before the court was whether or not there was in fact a power to expel Mr. Eaton. The LLP regulations mirror Section 25 of the Partnership Act. In the absence of an express agreement, there can be no expulsion. And so this decision does apply equally to a traditional partnership. As Mrs. Justice Proudman put it, accordingly, the defendants have to show that a power of expulsion was expressly agreed and that the circumstances in which such a power could be exercised. A power of expulsion is expropriatory in nature and is therefore always construed strictly. Mr. Eaton was a recruitment consultant, and since 2004, he had worked with Mr. Caulfield and others. Mr. Caulfield, a former city solicitor, specialised in partnership recruitment, whereas Mr. Eaton recruited mainly assistants and associates. Mr. Caulfield considered that he was superior and was very proud of his brand, Caulfield Search. They had marketed themselves as partners and considered establishing a limited liability partnership. There were discussions about how the fees should be allocated between them, which was fairly well documented in emails. At trial, Mr. Caulfield said that a power to expel on grounds of incompetence was also agreed, but Mr. Eaton said that it was not. Mr. Caulfield had presented several different versions of how the terms of the LLP had been agreed between them, but eventually stated that an agreement about the power for him to expel Mr. Eaton had been reached orally on a train journey, during which it was acknowledged that a lot of alcohol was consumed. There was evidence from two separate witnesses that no such agreement had been reached on that journey. It followed that in the absence of an agreement, there was no power for Mr. Caulfield to expel Mr. Eaton. So, apologies, wrong slide. So you cannot expel a partner unless an express agreement, an express power to do so is agreed between the partners. And it is section 19 of the Partnership Act that tells us the rights and duties of partners defined by the Act may be varied by agreement. Typically, this would be in the form of a written agreement, the partnership deed. So if you haven't got one, then my advice is to get one. And if you have got one, but you haven't looked at it for a long time, you haven't reviewed it, then review it and make sure that it allows you to do the things that you want it to do and prevents happening those things that you don't want to happen. Pay attention in particular to the decision-making process. Must all decisions be made at a face-to-face meeting? Who must attend? Who may not attend? Who can vote? Must a decision be unanimous? And what about connected parties? It may be unlikely that a husband or wife will vote to expel their spouse. So you have a partnership agreement, but who has read theirs? Just before you signed it, and never since, or at least until there's a problem. Many problems are not anticipated, and so the partnership agreement may not always give a simple answer. If there is no power within a partnership agreement allowing retirement, you could be stuck there forever. In fact, retirement or death, or any other mechanism by which a partner leaves a partnership at will, which is governed by the Partnership Act, will result in dissolution. However, partnership agreements invariably make provisions allowing a partner to retire when they wish to, although there may be certain notice requirements and restrictions which prevent multiple simultaneous retirements. Similarly, most partnership agreements provide that a partner may be expelled upon certain grounds or required to retire by the exercise of a compulsory retirement notice. This is what you will sometimes hear referred to as a green socks clause. Where there is no partnership agreement or no suitable provision, you will have to reach an agreement in suitable legal form about the exit. Expulsion on grounds is intended to deal with serious breaches of the partnership agreement and other specific and undesirable circumstances which are likely to be detrimental to the partnership business. Drunkenness at work, criminal conviction, struck off by the GMC, and so on. Compulsory retirement does not require a specific ground to be made out, but rather it allows the other partners to require a partner to retire without making out any ground, usually at the end of a short notice period. This may be useful where a partner is underperforming, which could be more difficult to establish if you had to rely upon a ground for expulsion. The other common use of compulsory retirement clauses is as a measure requiring compulsory retirement at a certain age, although, of course, purely age-based retirement may well fall foul of the Equality Act. Where you are contemplating an expulsion or compulsory retirement, you must read each clause and subclause very carefully and do no more nor less than it says that you may or must do. Expulsion and compulsory retirement clauses will be strictly interpreted by the courts. And so you must carefully consider what the clause says, the power that it imparts, and the process that must be followed to exercise that power. Get it wrong, and you may find yourself with a costly mistake, the expulsion declared invalid, and having to pay substantial sums to the injured party. If you are on the receiving end, then this provides a ground with which to challenge the expulsion. Any failure to follow process to the letter by the expelling partners will almost certainly render the expulsion invalid. Joseph and Delowitz is a recent case which emphasises the court's strict approach to the construction of these clauses. Mr. Joseph was served with a notice requiring his compulsory retirement. Mr. Joseph did not want to retire, and he did not much like the Delaware Board's decision that he should do so. The LLP agreement set out a process with 3 stages. Stage 1, the board may elect to issue a notice of retirement. Stage 2, the partner has the right to ask the board to meet and to reconsider its decision to issue the notice of retirement and to withdraw it. Stage 3, if the board has not withdrawn its notice and the partner is still aggrieved, he may, within 7 days of the date of such board meeting, notify Delaware to convene a partners meeting to review the board's original decision. The court considered the wording of the partnership agreement and held that its terms were clear and unambiguous. Time started to run for stage 3 from the date on which the board met, and so the 7-day period in which Mr. Joseph must ask for a stage 3 partners meeting ended on the 9th of October. He was a day late, and so he had lost his chance. The purpose of this 7-day period, the court said, was to provide certainty, and the clause imposed a strict deadline. They did not accept Mr. Joseph's arguments that time should run from the date on which he was informed of the board's decision, nor that the managing partners promised to notify him of the board's decision no later than the 9th of October should act as an estoppel. The managing partner had told Mr. Joseph that the board would meet on the 2nd of October and that he would be informed of their decision by the 9th. He was not informed. So the court held that the representation made by the managing partner went only as far as informing him of a date of the meeting and a date when they would tell him the outcome. Nothing was said about when he must exercise his stage 3 rights. The partnership agreement was clear and unambiguous, and the court was not prepared to interfere with its terms simply because Mr. Joseph had asked them to. It was observed, however, that the clause may not be well thought through, perhaps emphasising the importance of a periodic review of partnership agreements. Costs in that case, by the way, were quite substantial. So expulsion is a draconian step and it takes away an individual's livelihood. Many partnership agreements already make provision for the partner who is the subject of a proposal of expulsion to be heard and to be able to put their side of things upon the ground or grounds upon which it is suggested that he or she may be expelled. Even where a partnership agreement does not include such a provision, it may be wise to allow them to have their say. The decision to expel has been framed as a quasi-judicial function requiring natural justice, an unbiased decision to be made upon the matter once both sides have been heard. AX and BY was a construction dispute that went to arbitration, and it's useful in demonstrating the problem that accrues from potential bias. Certain without prejudice correspondence have been put in front of the arbitrator, and so the court, when asked to enforce the arbitrator's decision, refused to do so because there was a real risk that the arbitrator's neutrality may have been affected in forming his decision because he had seen this material. Similar bias could arise where a partner is not allowed to state their case. Lord Justice Dyson in AMEC states, "The common law rules of natural justice or procedural fairness are twofold. First, the person affected has the right to prior notice and an effective opportunity to make representations before a decision is made. Secondly, the person affected has the right to an unbiased tribunal." Rennie and Rennie is a Scottish decision, and unlike in England, in Scotland, partnerships have a separate legal identity. So this case is not binding in the English courts, but nonetheless it is of interest and influence. In Rennie and Rennie, the court found that it was clear from the terms of the partnership agreement that a condition for expulsion had to be met and a decision made, and this conferred a quasi-judicial role on the other partners when considering and deciding upon whether to expel, and so the rules of natural justice are engaged, including the need to give fair notice of the grounds for the proposed expulsion and the right to be heard prior to any decision being made. The court held that since none had been given, the rules of natural justice had been breached and the expulsion was invalid. There are a number of cases supporting this approach, although they're not English partnership cases, because the decision to expel a partner may be viewed as a quasi-judicial act. There may, of course, be contrary arguments where partners have considered the question of allowing any right to be heard, or even to be given notice of a meeting at which a proposal to expel will be considered before they have executed the partnership deed. And so having considered this, they've concluded that the right thing to do is to expressly exclude it. The Association for Dance Music Psychotherapy was a company which promoted dance movement for psychotherapy for its members, and Catherine Dimmock had been a member since 2002. She undertook a teacher training course in mind-body centering and was subsequently appointed to teach a master's course that contained a module on mind-body centering at Edge Hill University, which was licensed by the association. That's the course rather than the university. When Ms. Dimmock's teaching contract was not renewed, she argued that the course could not proceed without her. The association started to investigate possible conflicts of interest at that time, and its executive decided to terminate her membership, effectively to expel her. Ms. Dimmock claimed that, amongst other things, the termination procedure had breached an implied term of natural justice. She'd not been able to put her side of things before a decision was made to terminate her membership. The court implied a term into the membership contract that the association's decision-making powers were subject to natural justice, and so there existed an obligation of procedural fairness. It was an implied term of the contract that she should be treated fairly in relation to the termination and informed of any complaints with enough detail that she could understand them, and then be given a reasonable opportunity to respond. ACK is an interesting case as it involves both suspension and expulsion. The claimants were both members of a faith-based association governed by a constitution and led by an elected body known as the Shura and a central president. Both claimants and one defendant had been elected to the Shura and the other defendant to the position of central president. The Shura suspended and then expelled both claimants because they said the claimants had been offensive towards the central president and other members of the Shura. The claimants said that they had raised legitimate concerns that should be heard and that the decision-making process leading to their suspension and expulsion was contrary to natural justice. They also argued that the election of the central president and Shura should be declared void due to irregularities in the voting process, and so that any decision subsequently made was invalid. On the facts, the court found that they failed on the second point, but that the Constitution required a member to be given opportunity to defend themselves before the Shura. The power to expel must be exercised in good faith. The member must be informed of the allegations against them and then allowed to respond, and the decision to expel made by an unbiased decision maker giving reasons. The expulsion was invalid, but minimal damages were awarded. The decision to suspend, however, was based on a credible belief of misconduct, and reasons for the suspension were clearly enunciated. That decision had not been exercised in bad faith, for improper purpose, or irrationally. It was of temporary position pending a final decision. I cannot emphasize too strongly the need to make these decisions in good faith and for the benefit of the partnership as a whole. Good faith is not an automatic construct in English law, but it arises or may be implied in certain circumstances. The duty of good faith in a partnership is clearly stated in Helmore and Smith as a principle arising where there is a fiduciary relationship. The duty of good faith exists in partnerships whether or not there are expressed written terms in the partnership deed. It is perhaps helpful to contrast this with the position in contract in order to understand the court's approach to implying terms. Marks and Spencer's and BNP Paribas involved a commercial lease under which the tenant, in accordance with the contract, gave the landlord notice of its intention to exercise a break and bring the lease to an end early. The lease provided that the rent should be paid in advance on each quarter day. If the tenant wished to exercise the break clause, they must pay the rent because if in arrears, they could not exercise the break. They gave notice in accordance with the lease, and as required, they paid 1 year's rent as compensation to the landlord. The tenant also paid the quarter rent in advance, but the lease terminated without them enjoying the full benefit of that period, and they claimed that the rent should be refunded to them along with the service charges for the period after termination. Where parties had agreed to express terms, the court would start by looking at and applying these, and only in limited circumstances would they be prepared to imply any term into a contract. These include, through usage or custom, a previous course of dealing, to give effect to the intention of parties, as had been ascertained by examination of the facts, or at common law through previous decisions of the court, or under legislation. The court considered each party's case and decided that the parties had agreed detailed terms, and if they had intended there to be a refund, then they would have provided for it in the lease. There was no common law duty or statutory basis for a refund, and the intention of the parties was recorded in the lease. The service charge, however, was a different matter because the lease specifically allowed for apportionment. We're probably all familiar with the Post Office Horizon scandal and Alan Bates case. In Bates and the Post Office number 3, the High Court considered a preliminary issue, the characteristics that give rise to a relational contract. The court examined the contractual words. The nature of contracts between sub-postmasters and post office were found to be relational, and so there was an implied obligation to act in good faith. Whilst the relationship was contractual, the court outlined characteristics that may give rise to that relationship in which the obligation arises. No one feature is determinative other than the first. The Post Office required sub-postmasters to use Horizon. There were unexplained shortfalls, and the 2011 sub-postmasters contract provided that they were liable for almost any shortfall in the accounts, however arising, and that they must make up that shortfall. The sub-postmasters were agents of the Post Office, and this required and were required to account using the Horizon system. As such, the relationship was fiduciary, that of principal and agent. The group litigation that followed challenged the actions of the Post Office and made claims for compensation. This phase of the litigation looked at the contractual provisions and the application of good faith in the relationship. Parties must refrain from conduct which in context would be regarded as commercially unacceptable by reasonable and honest people. The following non-exhaustive characteristics were relevant in deciding whether a contract was relational. Of course, the partnership relationship is also a fiduciary relationship. The court, having established that such a relational contract existed, requiring the exercise of good faith, felt able to imply numerous terms into the sub-postmaster's contract. The judge held that of 21 possible implied terms that have been advanced, 17 should be implied into the sub-postmaster's contracts. Those terms included obligations not to take steps which would undermine the relationship of trust and confidence between the parties, to exercise any contractual or other power honestly and in good faith and for the purpose for which it was conferred, not to exercise any discretion arbitrarily, capriciously, or unreasonably, and to exercise any such discretion in accordance with the obligations of good faith, fair dealing, transparency, cooperation, and trust and confidence. They also included more specific duties about record keeping and cooperation, and not to seek recovery from a sub-postmaster unless and until the Post Office had carried out a reasonable and fair investigation about whether any shortfall was properly attributable. And so we can see that in the context of making a decision about a partner expulsion, there are some key concepts to keep in mind about acting in good faith. And the statutory position. The Partnership Act tells us that there exists between partners a relationship of mutual agency. Under the Act, every partner can make a bargain with a third party on behalf of all of the members of the partnership. Each partner is an agent of every other partner, and an agent owes a fiduciary duty to his or her principals. And if that duty is breached, the principal may be entitled to a substantial remedy. That remedy may, in some circumstances, be more than the loss actually caused by the breach. I'm going to give you an example of that, a case called Image View and Jack. And Kelvin Jack was a professional footballer, a goalkeeper from Trinidad and Tobago, and he said to his agent, "Go get me a job in the UK." And so, if you do that, I'll give you 10% of my income for the duration of that contract. So the agent went and got him a contract with Dundee United, and the agent said to the football club, "I can arrange all of the work visa and immigration work, and I'll charge you a fee for that." I think he charged him about £3,000. So the contract went on, and then Mr. Jack discovered that the agent had this side deal, and so he was able to recover all of the money that he paid to Mr. Jack, to his agent, as well as the £3,000, because the agent should not have received any of that, and had only done so by breach of his fiduciary duty. Of course, many partnership agreements will contain express provisions about partners' duties, and there may be limits of a partner's authority to commit the partnership to expenditure without a decision being made at a partners' meeting first. So here are some important cases. Bristol and West Building Society and Mothew. This concerns a solicitor acting for a lender and a purchaser in a conveyancing transaction. And so they are the agent of the lender. And the judge said, a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interests may conflict. He may not act for his own benefit or the benefit of a third person without the informed consent of his principal. Daniel and Blissett is a partnership case which predates the Partnership Act. The senior partner wanted to bring his son into the partnership and to manipulate the distribution of profits, so he persuaded the other partners to vote with him to expel Mr. Blissett. The court found that the expulsion was for his own collateral purposes and was therefore invalid. In Moody and Jones, Daniel and Blissett was considered and followed. In the more recent case here, His Honour Judge Coulson says at paragraph 236, as an incident of a partner's duty to act in good faith, it is necessary that a partner serving an expulsion notice, or as it was in this case, a notice of dissolution that is of like effect, should do so acting bona fide for the benefit of the firm as a whole and not for the serving partner's own ends. Braganza and BP Shipping. Mr. Braganza went missing at sea. He was the chief engineer of a tanker operated by BP Shipping. His employment contract provided for a death in service benefit to be paid to his family, but if he had committed suicide, then that benefit would not be available to his widow. Following his death, his employer set up an inquiry to investigate the relevant circumstances leading up to the loss of Mr. Braganza's life and to identify the root causes of the incident and any changes required to their safety management system. BP established an inquiry team comprising of 5 members, and after 4 months, they concluded that there were 2 possible explanations for Mr. Braganza's death. Firstly, that he committed suicide, and secondly, that he fell accidentally to his death. They concluded that the former was the more likely scenario, based upon a certain range of factors and considerations that they set out in their report. That report was passed to Mr. Sullivan, who was the employer's decision maker, and he, in due course, relying upon it, concluded that Mr. Braganza had indeed committed suicide, and so his widow should not be paid any death benefit. Mrs. Braganza challenged that decision through the court, and on appeal to the Supreme Court, it was held that the decision made by BP was unreasonable. The court relied upon the earlier test of Wednesbury reasonableness. Lady Hale said, "This case raises two interlinked questions of principle, one general and one particular. The particular issue is the proper approach of a contractual fact finder who is considering whether a person may have committed suicide. Does the fact finder have to bear in mind the need for cogent evidence before forming the opinion that a person has indeed committed suicide? The general issue is what it means to say that the decision of a contractual fact finder must be a reasonable one." And she continues at paragraph 36, "The employer is entrusted with making a decision which has serious consequences for the family of a deceased employee. It deprives them of what would otherwise be a contractual right. There is no reason why the employer should not approach that decision in the same way that any other decision maker should do. In my view, a decision that an employee has committed suicide is not a rational or reasonable decision in the terms discussed above, unless the employer has had it clearly in mind that suicide is such an improbability that cogent evidence is required to form the positive opinion that it has taken place." The court considered the test of Wednesbury reasonableness and considered that the decision maker must, one, not have given relevance to facts that in reality were irrelevant to the decision-making process, two, have given relevance to all those facts that were relevant and worthy of being considered in the decision-making process, and three, having made a decision based upon the factors above, further consider whether they had reached a conclusion that was so completely absurd that no reasonable decision maker could possibly have made it. Decisions to expel a partner may have similarly draconian effect and are often challenged. The decision in Braganza points to the requirement that decisions must be rational, and in making them, the decision makers must take into account all of the relevant facts and disregard all of the irrelevant facts. Even then, if all those matters that ought to be taken into account have been considered, and any matters that ought not to be taken into account have been disregarded, is the decision that was arrived at one that no reasonable decision maker could ever have come to? The final case, Conlon and Sims. Sims and Conlon were solicitors. Sims wanted Conlon to join him in partnership, and he misled him in a number of material ways during the discussions about the prospective endeavour, both about his client following and his own regulatory record. Sims had acted in bad faith, and Conlon was induced to go into partnership. The court held that the duty of good faith applies during these negotiations before the partnership is formed, as well as during partnership. That duty of good faith also pertains after a partner has left. So we know that we must read the clause carefully and consider whether any particular ground for expulsion is made out. Some will probably be more clear-cut. If the partnership agreement says that if you're made bankrupt, you may be expelled, then you either have or you have not been declared bankrupt. Similarly, a criminal conviction or being struck off following a GMC investigation are matters of certainty, notwithstanding any possible appeal. But what if a clause is prefaced with something like, if in the reasonable opinion of the partners there has been a serious or persistent breach? what is a reasonable opinion, and what amounts to a serious or persistent breach. Does arriving at work later than agreed amount to a serious breach? Well, maybe it depends on the context. If you were going to carry out transplant surgery with a donor organ that will perish, then later arrival may be quite catastrophic. But if your train is 5 minutes late, but you're on time for your clinical appointments, then maybe not. And what if you are 5 minutes late every day, but still able to perform all of your duties? Is using your own accountant rather than the partnership accountant to prepare and file your personal accounts a serious breach if the partnership agreement says that you should use the partnership accountant? The answer to these questions will often be very fact specific. In THJ Systems and Sheridan, the court considered that a serious breach is one that is more than trivial but less than repudiatory, and a persistent breach must be repeated, non-trivial, and in the whole amount to something with a serious impact. And has any breach been ignored or tolerated? If so, and depending upon the factual circumstances, this may give rise to a waiver of the breach. If you've accepted it over time, you may have lost the opportunity to complain about the breach later. So, where you want to rely on grounds within the partnership agreement for expulsion, you must have evidence. If challenged, or if you are on the receiving end, you may challenge where none exists, and any opinion must be formed reasonably and in good faith. Proper investigation of the facts will become crucial in the event of a purported expulsion and challenge from an expelled partner. British Home Stores and Birchall is a 1978 employment case, but the facts and principles are relevant to partnership expulsion. At BHS, there existed a scheme where staff could purchase items offered to the public in the sale on more advantageous terms. There was a standard procedure for making these purchases. The employer, having become suspicious that this was being flouted by Miss Birchall and others, carried out observation over a period of 6 months of items purchased under the discount scheme, finding that 4 employees had signed dockets for one another and allowed discounts which were in excess of those provided for under the staff scheme. Based upon this evidence, the management had formed the view that Miss Birchall was dishonest and had dismissed her. Miss Birchall had succeeded in her claim against that dismissal in the employment tribunal, and so she had been reinstated. She did not attend the appeal hearing. The appeal court held that Miss Birchall had been dismissed because the BHS management believed that she had played and abused a system, allowing staff to buy goods from the store at a discount, and that it had in fact been reasonable for the management to form the opinion that Miss Birchall was dishonest following a reasonable investigation, albeit that the information that they had relied upon would not have been enough for a criminal prosecution to have succeeded. Discrimination. So, Section 4 of the Equality Act 2010 sets out a range of protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. The Act makes it unlawful to discriminate directly or indirectly on the basis of a protected characteristic, save in very limited circumstances, to achieve a legitimate aim. Section 44 of the Equality Act applies specifically to partnerships. Such discrimination is to be challenged in the employment tribunal within 3 months. In Mullins and Lawton, Mullins alleged that he'd been asked to attend a meeting at short notice, and that at the meeting he was told that his involvement in the partnership was at an end, that he was to be excluded from the offices which he ran, and that he owed the partnership a substantial sum of money. Not long after the meeting, Mullins' partners tried to force a number of files on him and served a statutory demand on him. Mullins argued inter alia that the actions of Lawton and the other partners amounted to a repudiatory breach of the partnership, which he had accepted. This behaviour, which may be described as bullying, was found to be contrary to the duty of good faith. So, what now? We've run through a range of different important considerations if you are considering expulsion or compulsory retirement, and the steps that you need to consider. To summarise, you need to understand what you can and cannot do under the terms of a partnership agreement, or if there's no partnership agreement, what alternatives may be open to you. You need to follow the process that's set out in any partnership agreement to the letter, make rational decisions in good faith and without bias. And if you don't, you may have to face the consequences. If an expulsion is shown to be invalid, that partner must be treated as if they were never expelled, and so they will be able to return to the partnership, or alternatively, they will be compensated in damages and costs. So if you're on the receiving end, take advice and consider whether you challenge any expulsion. If you are on the end or the partnership end and you are considering the expulsion of a partner, take advice early and hopefully avoid any problems. Yeah, and of course, if you're going to consider the scenario, then you need to weigh all of your options carefully. Most of these cases, in reality, end in some form of compromise, because nobody really wants to go to court or to arbitration and spend a fortune on legal costs, where some lesser expenditure at an early stage may have allowed them to avoid that. So that's the end of this talk. Are there any questions? Right, I can see that we've got 11 questions here. So we have an anonymous question. Asking whether GP partners are allowed to expel a partner, excuse me, after initially suspending. Well, that's going to depend on what the partnership agreement says. Awaiting a GMC outcome. Well, I think that's probably going to boil down to the position with the GMC investigation and the exact wording of the partnership agreement. Probably one that's best discussed offline. And a question about green socks. Can partners use it if it's never been brought to the attention of a partner who has been expelled? Well, a green socks clause is if it's included in the partnership agreement and all the partners have signed that agreement, or if they've joined later, they've entered into a deed of adherence. We at BMA Law would usually advise partners to take independent advice about entering into an agreement which contained a green socks clause. I can't immediately see how there could be a situation where a partner wouldn't be aware of the green socks clause. But again, it's probably one that needs a bit more detailed discussion offline. Let's see. Okay, well, that's a fairly straightforward one. Are you going to send the recording? Yes, I think the answer is it will be available to you. Um, okay, so does the case of natural justice supersede any partnership agreement allowing for notice, i.e., no notice in partnership agreement, but they should give notice anyway? So it's many partnership agreements will specifically provide for a partner who's on the receiving end of a notice of expulsion, or sorry, let's wind back. A partner who is under consideration for expulsion to be able to have their say, to put their side of things to the other partners who are going to make that decision. Um, if the partnership agreement says that that must take place, then that must take place. And if it doesn't take place, there is at least grounds to challenge the expulsion. If the partnership agreement is silent upon it, yeah, the right to be heard, um, there is nonetheless an argument that can be made about the existence of natural justice because of the relationship and the nature of the decision that's being made. So again, it probably that's the generic answer. Um, it's probably one for closer scrutiny in a different forum to look at the specific circumstances. Why is good faith required for green socks? Okay, so green socks or compulsory retirement, um, it does not require a specific ground to be made out, as in an expulsion case, but the other partners can make a decision to ask a partner to retire. So that's the green socks. Conventionally, we talk about we don't like the colour of his socks or her socks, so we're going to ask them to leave. However, it's a decision that's being made by partners about another partner, and the existence of that fiduciary relationship, the duty of good faith between partners, requires that decision to be made in good faith. So that is the obligation that arises as a result of the relationship between partners. Um, so that's point one. That's why the decision to compulsory retire or green socks a partner must be exercised in good faith. And the other important component is that that decision cannot be made on discriminatory basis. So in making or arriving at a decision, you have to have in mind the possibility that you may be discriminating against the partner who's subject to that decision under consideration. Again, if there are more specific questions about the specific situation that this concerns, then please get in touch and we can discuss that further offline. Okay. How does green socks differ from expulsion? Well, expulsion, um, yeah, this depends on the wording of the partnership agreement, because I have seen what is effectively a compulsory retirement clause included within the expulsion clause. Um, but expulsion requires a usually expulsion requires a ground to be made out, and the green socks or compulsory retirement is the other partners arriving at a decision to ask, yeah, ask and oblige the subject partner to retire. So no ground needs to be made out. But as I've said previously, subject to the duty of good faith and not discriminating. Um, I've got quite a number here that look quite specific, and I'm conscious that both you and the person on the other side could be um, with us today. Is there such an issue as constructive dismissal under partnership law? Well, constructive dismissal is an employment construct. Um, I think the Mullins and Lawson case involved pressuring a partner, and so this would essentially come, and it's a whole other talk, but this would essentially come down to the duty of good faith. So if pressure is being put on a particular partner such that they feel that there's no alternative but to leave, then perhaps we can investigate that. You can look at it by way of analogy to constructive dismissal, but that does not exist in a partnership relationship of itself. But a breach of the duty of good faith may give rise to a claim or an action which would allow you to rectify things. I'm not sure if that quite answers your question, but if not, then please please do come to me, and we will address that in more detail. So I think we're reaching the end of time, um, and thank you very much for attending today. I hope this has been useful to you. Have a great rest of your day, and if you need advice about any particular dispute, then please don't hesitate to get in touch. My colleagues will be able to assist you with questions about regulatory matters, or for those of you that haven't yet got a partnership agreement, preparing one that will meet your particular needs. Just contact BMA Law. Um, thank you.